So in the previous lesson, we spent a little bit of time talking about the nature of a basic license or a bare license as sometimes described. This lesson is just going to carry on talking about the various different types of licenses that can exist within the broader context of land law, focusing on the idea of the contractual license and contractual licenses. We're continuing to look at the various different types of licenses which may exist. So far, we've spent some time looking at the idea of a bare license on the one hand, which is just simply a basic permission, a basic right that can exist. If I were to invite my friends round for some drinks, I would be giving them license to enter onto my property. We can also think of the idea of licenses which are coupled with an interest. The idea being that in order for an interest to be valid, there may be the requirement of license over a certain property. This may exist in relation to various different types of covenant and specifically also things relating to easements, which we'll get to in future lessons' time. This lesson is going to examine the next kind of license which we can think about, sometimes known as contractual licenses, or alternatively you could label it a license coupled with a contractual obligation. Either of those is fine in terms of how you were to define it. An examiner or an individual who is reading a paper or exam of yours would presumably know that you're talking about the same thing if referencing either of them here. So let's just think about it then. So a contractual license or contractual licenses or licenses coupled with a contract may arise in circumstances where you enter into a contract with valid consideration. For those of you who haven't studied contract law so far, you must know that in the English legal system, there is not the recognition of contractual arrangements that do not have valid consideration, or sort of one-sided contractual arrangements. So a contractual license, therefore, will arise out of circumstances where one enters into a contract, this contract has attached to it valid consideration, and this gives you some access to property as part of the license. For example, if I were to purchase a ticket for a theme park, the contract that has been created is the ticket for the theme park, but I also have a license, therefore, to enter into the theme park for the period of time that is allowed under the contract. If I were to purchase a train ticket or a tram ticket, I have license to enter onto a tram or a train for the duration of time that the ticket permits. And so this is the idea of a license which arises out of a contractual arrangement. And simply put, it will begin at the time at which the contract says that the license is valid. So if we go back to that theme park example, if I were to buy tickets for a theme park and it says that I can only use the theme park on the 20th of June, for example, maybe I buy them in advance, then the license does not exist until that contractual time period has begun. And then for the time on the 20th of June, I have license to do and go around the theme park and act, obviously, within the remits of a contract, of course, not causing anything that would get me kicked out of a theme park. This therefore means that if I have a contractual arrangement that exists, and as part of that contractual arrangement, there is the requirement that I have license to enter onto some property. If that license is revoked, then this will amount to a breach of contract, since it is a fundamental characteristic of the contract itself that I have license over that property in question. So again, going back to the theme park example, if I, for any reason that does not, if I have not breached the contract myself, if I purchase a ticket for a theme park and then all of a sudden some security guards come and kick me out and remove my license, then they have breached the contract, because as part of the contract that I have with the theme park, I have license to enter onto their property, onto the theme park. That's the whole point of the contract in the first place. Now, if I were to breach the contract, if I were to do something and act in a way that would get me kicked out, then I would be the one in breach of the contract, and therefore my license would be revoked. It does not mean, however, that there is no way to revoke a contractual license. If it can be done in some circumstances where there is reasonable notice, and that there is the acquisition of damages as a remedy for the breach of that contract. So there are theoretical examples for where we can understand a license actually be revoked in a way that does not just automatically arise out of a breach of contract. If reasonable notice is given and there is damages or remedy for contractual breaches, then this can be a valid way to revoke a contractual license. There are, of course, however, limits on the termination of a contractual license. The courts have recognized that in certain circumstances, a license was intended to be irrevocable, that you cannot revoke a license in a contractual arrangement. For example, in cases where a contract is formed for the purpose of doing work, and that the license is not to be revoked until that work is performed, until that work has been completed. In those kinds of circumstances, therefore, an injunction, in fact, may be granted, and that this injunction could be granted to prevent the premature termination of a license. And such examples can be given to illustrate this point. And I point here to the case of Winter Garden Theatre versus Millennium from 1948. In this case, the defendants were the owners of a theatre who had granted license to a theatre company. Within that license, there was the option for the contract, and as a result of which the license itself, to be extended. There was an extension option. When the claimants, the company, sought to extend, the defendants instead sought to terminate the license. This was in fact a part of the breach of contract, since there was no provision within the agreement to allow the defendants to terminate the lease. And so there was a disparity here between the Court of Appeal and the House of Lords, because the Court of Appeal, in fact, suggested that the license had not been revoked, whereas the House of Lords, in fact, said that it had been revoked. The disparity in judgment in this case came from the fact that there was a different interpretation of the way in which the contract was to be viewed. On the one hand, we have the general view here being that the terms of the contract are particularly illustrative as to whether or not a license which arises out of said contract can be revocable. Now, obviously, because the House of Lords disagreed with the Court of Appeal and the House of Lords had the final say, it was the decision and the ruling of the House of Lords which actually had weight in this particular judgment. But what this does is illustrate quite an interesting disparity, like I say here, a disparity between the reasoning and the rationale behind the Court of Appeal on the one hand, and the House of Lords on the other, which have then viewed this entire situation slightly differently, in a way that therefore meant that there had been a revocation of the license, whereas the Court of Appeal believed that there had not been a revocation of the license.